I'd like to introduce our next speaker, which is Understanding the Care Act. And this is Monica Kreel. And she's a community care and public law solicitor with the TV Edwards Solicitors. Welcome.
This one. This one.
Yeah, that's
forward.
Just speaking.
Okay. Is that the move on button? What's the buttons for the slide? Are these the buttons for the slides as well?
Oh, no,
I'm
doing that.
Oh, lovely. Thank you. Okay. Are we ready?
Yes.
Oh, hello everybody. Can you hear me okay? No. Right. Can you hear me better now? No? Is the microphone not on?
Yeah, it should be.
Okay, can you hear me now? Is that better? Lovely, okay. Right, so my name is Monica Kreel. I'm from a solicitor's firm in Whitechapel called TV Edwards Solicitors. And I'm a community care solicitor and a quarter protection solicitor. And I've been asked to come and do a short introduction to the Care Act, to your rights and your the rights of the person receiving care or not receiving care under the Care Act. And so I'm going to try and get through this fairly quickly because I know that this is the end of a long day and I've got a lot of slides. There's going to be a short case study at the end. Just let me know if I'm going too slowly or too quickly and you're not able to sort of follow what I'm saying, okay? So also, would you just help to... Okay, could you let me know if we're getting like maybe 10 minutes before the end of time? Thank you. Thank you. Oh, we've got a clock there, lovely. Okay. So what we're going to cover is we're going to cover the Care Act. What is it? We're going to look at the framework, the Care Act framework for assessments, eligibility decisions and planning. Can you hear me okay? Yeah? We're going to look at transition planning, which is children to adult services, carers assessments, Care Act assessments and plans, and some important kind of extra bits of information that are useful to know about those assessments and plans, so that you can see that they're being done properly. What a Care Act decision means in legal terms, which I call a public law decision, and practical steps for challenging an assessment or plan. And then I'm going to briefly cover the Mental Capacity Act, because that's also relevant to maybe not all of you, but to some of you, and it's a very, very important legal framework for people who don't have capacity to make decisions for themselves. So I have to just do an important note here, which obviously is this training or this talk is to help you to understand your rights and the rights of the people you care for better. It's not legal advice, because legal advice would obviously have to be tailored to your very specific circumstances, and it may involve lots of other bits of legislation, not just the Care Act, not just the Mental Capacity Act, but all sorts of other things as well. Right. Are we up to date? Yeah. The Care Act. So what is it? The Care Act is the central piece of legislation that covers the care that disabled adults receive from adult social services. And it doesn't apply to children. That's a really important thing to be aware of. So it sort of kicks in aged 18, although there's some transition provisions. So the law that covers disabled children, or one of the laws that covers disabled children, is Section 17 of the Children Act, and also Section 2 of the Chronically Sick and Disabled Persons Act. So the law covering children is still a little bit all over the place. It's incorporated into lots of different laws. So you've also got the Children and Families Act, which covers education. Whereas with the Care Act, the law was such a mess that they decided to bring it all together in 2014 and make one piece of legislation that covered, a lot of the care services and the assessment process for disabled adults. People often wonder about accommodation under the Care Act, and there's a difficult relationship with the Housing Act. So generally speaking, and we'll look at this a little bit later, generally speaking, accommodation can only be provided under specific circumstances under the Care Act. So certain types of accommodation only can be provided under the Care Act. General accommodation can't usually be provided under the Care Act. That would be under the Housing Act, but we'll look at that a bit later. So just because I know that carers have had to be, in their lives, advocates for themselves and for the people that they care for, so are interested in looking up the law, generally speaking, and looking up sources of information. I'm telling you the sources of information that you can look up for yourselves if you want to just understand things a bit more. So the primary legislation we're talking about is called the Care Act 2014. There's also a very useful and long guidance document, which is statutory guidance, which means that it's guidance that local authorities or public bodies must follow. In, well, some circumstances they can say, well, no, this doesn't apply, but generally speaking, because it's statutory, they should follow it, and that's called the Care and Support Statutory Guidance. So it's an online-only document. It gets updated every few months. So you can just Google that and have a look, and you can search it. It's got a search function. You can find the sections that you're looking for, or the types of things that you're looking for, like assessments, planning, carers assessments. You can look up things in there. And then there's some very important regulations. So regulations are kind of bits of sub-legislation that are made under an Act of Parliament. So the regulations, there's loads of them under the Care Act, but the important ones you need to be aware of are the Care and Support Eligibility Criteria Regulations, which set out the eligibility criteria for getting care under the Care Act, and also the Care and Support Assessment Regulations, which tell you a little bit more about how assessments should properly be done. So the bit of the Care Act that is concerned with assessments is Section 9 of the Care Act. And the important thing to note is that it says where it appears to a local authority that an adult may have needs for care and support, the local authority must do the Care Act assessment. So a local authority shouldn't sort of stop things at a stage that's too early. They shouldn't say, we're not going to do a Care Act assessment because we don't think this person has needs, because the threshold is really low. It just says they may have needs, but then again, they may not. But the only way that the local authority is going to find out is if they actually do the assessment. And then there's another assessment duty, which is under Section 58 of the Care Act, which is similar to the main assessment duty under Section 9, but it's just talking about where it appears to a local authority that a child is likely to have needs for care and support after becoming 18. So I said that the Care Act just applies to 18-year-olds and above, because it applies to adults. But it does kick in earlier in terms of the transition assessment and the transition planning. So it kicks in at an earlier age. So I'm going to move on to the next slide, the key points that I think would be useful to know about Care Act assessments. So I've already said that the threshold for assessing someone is low, but what I'm finding with the cases that I've got is that there's a lot of gatekeeping that goes on by councils who say that we're not going to do an assessment because the person won't be eligible. And they might say that, before they've even investigated whether the person will be eligible or not, that the family is already providing care, or they say things like they don't have the correct immigration status, so we're not going to do an assessment because they won't be entitled to anything, or they say that the person is the responsibility of a different local authority. I'm also seeing things more and more that local authorities are saying, well, we've got a waiting list for Care Act assessments. And you're thinking, well, if somebody's got needs, those needs must be assessed because the council's got a duty to meet those needs. So you can't just keep somebody on a waiting list. There isn't a thing. It's not a thing, a waiting list. It shouldn't really exist. So I would suggest if somebody's got urgent needs, don't say, well, that's fine, they're on a waiting list. They should be having the assessment so that their needs can be met. So as with every stage of the Care Act, whether we're talking about the assessment, we're talking about a care plan, we're talking about a care plan review, every stage, or a transition assessment, every stage, social services needs to think about the well-being criteria. So they're all set out at Section 1 of the Care Act. And those are the things that the council must take into account when they're doing all of these things, assessment, planning, reviews, anything like that. So there's a whole list of well-being criteria that need to be taken into account, and these are listed here at Section 1 brackets 2, and it's things like personal dignity, physical and mental health and emotional well-being, protection from abuse and neglect, control by the individual over day-to-day life, participation in work, education, training, or recreation, which is often something that's quite downgraded because it's seen as a kind of a nice-to-have extra. But it's up there. It's as important as everything else. Social and economic well-being, domestic, family, and personal relationships, suitability of living accommodation, the individual's contribution to society. So it's all of these things must be taken into account. They need to be sort of threaded through every assessment, and they're things that you can raise. If you see an assessment and you think, well, they haven't really thought about this, they're just giving me the bare minimum, but they're not really thinking about the person's participation in work, education, or training, or they're not really thinking about their autonomy or the risk of abuse. You can use some of these things and think about things from the perspective of well-being. Another important thing to be aware of when an assessment happens is that the person doing the assessment must look at the person's needs as if they don't have any current provisions. So it's looking at the person's actual needs. It's not looking at what's left over that hasn't been met yet. It's sort of stripping it back and thinking, imagine this person had no care, no family care in place, no care package in place. What would their needs actually be? I'm going to just move on to the eligibility criteria for being eligible for care under the Care Act. And these are set out in the eligibility criteria regulations, which I mentioned. If you go back to one of the early slides, I think it's slide 3 or 4, you'll see that I've mentioned that there's some very important regulations under the Care Act, and this is one of them. And this sets out the legal test for somebody qualifying for care. And it says that there's kind of three main parts to it. So the person is basically, so part 2A, where it says the adult's needs arise from or are related to a physical or mental impairment or illness. So it's basically saying we're talking about disabled people here. We're not talking about care needs that might arise from something else like pregnancy. We're talking about actual care needs that arise from a person's disability, whether that's a mental health issue, learning disability, autism or physical disability, or brain injury or anything like that. As a result, and then B is, as a result of the adult's needs, the adult is unable to achieve 2 or more of the outcomes, and we'll look at what those outcomes are in a minute. So there need to be 2 or more things that they can't do or that they have difficulty in doing. And then the third one is that as a consequence, there is likely to be a significant impact on their well-being. And then that takes you back to, do you remember we were talking about the well-being issues in section 1? It takes you back to that, the significant impact on the person's well-being. So the important, really, really important thing to be aware of, and you will have seen this if you've seen any Care Act assessments, you will have seen these categories laid out, and you will have had these questions asked about how the person manages with all these different things. So there's specified outcomes which are on 2 pages of the slide. So they go from A to J, and so there's these different outcomes that the social worker will be trying to work out whether, or will be asking questions to see whether this person can achieve these outcomes or not. So they are managing and maintaining nutrition. So that could be anything from shopping for food, cooking, or it could be managing to eat themselves without assistance, or it may be that they have, if in mental health terms, they may have no motivation to eat, or it may be that in medical terms they have, they're fed through a feeding tube or a peg. So it can cover all of that type of issues relating to food and nutrition. And if you want to kind of understand what each of these outcomes are in a bit more detail, the place to go is to that Care and Support Statutory Guidance that I mentioned was the online document. And you can find these really easy. It's quite an intimidating document when you first look at it, but if you just use search terms such as managing and maintaining nutrition or specified outcomes, it will take you to the place of in that online document where you've got wider descriptions of all of these outcomes, and you can see how they might apply to your loved one's circumstances or the person you're caring for. So the next one is maintaining personal hygiene. So that will be things like washing, showering, bathing, brushing teeth, washing hair, managing toilet needs. So that might be, issues around continence or getting to the toilet. Being appropriately clothed. So that includes things like knowing what clothes to wear for the weather. And that's often something that people can't manage to do. Or putting on clothes or keeping clothes clean, that type of thing, whether they can't do that themselves. Being able to make use of the adult's home safely, so that it may be around sort of access to the home, whether the home's accessible and whether they need any aids or adaptations in the home. So then we're getting on to the last 1, 2, 3, 4, 5 of these on the next slide. Maintaining a habitable home environment. So it's things like, can they, if they lived on their own, would they manage to be able to pay bills? Would they manage to sort out all their finances to keep a roof over their head? Could they do that themselves? Or it might be around keeping the home clean. And then I mentioned before, when we were talking about well-being, that some types of needs are a little bit sort of downplayed, or they're seen as kind of second-class needs somehow, but they shouldn't be, because they are just as important as all the other needs, all the other outcomes. So developing and maintaining family or other personal relationships. Somebody may look like they're managing physically okay at home, but what about some of these other things, like maintaining relationships? Being able to make friends, for example, or get on with family members. H, we've got accessing and engaging in work, training, education or volunteering. That's really, really important at any age, but you think particularly for a young person who's maybe coming out of education, formal sort of statutory education, then what other things are they going to do with their life then? Making use of necessary facilities or services in the local community, including public transport, recreational facilities. So yes, somebody's life will only be complete really if they can actually go out and do things. You know, we don't want somebody just existing. You know, the Care Act supposed to be, when it came in 2014, it was meant to be aspirational. It was meant to be about people living full lives. So all of these ones on this sort of, I would say, G to I, the personal relationships, accessing, engaging in work, accessing the community, they're all really, really important ones as well. They're all really important outcomes. And then the last one is carrying out any caring responsibilities the adult has for a child. So we're talking about the disabled person here. We're not really talking about a carer at this point, because this is all focused on the disabled person themselves. So when the Care Act says that the person's being assessed to see whether they can manage these outcomes, the question is, can they manage them? So it's not just, they won't just qualify if they just can't manage these things at all. It may be that they can't manage them without help, or it may be that it causes them significant pain, or it takes them a very long time, or that it's dangerous. So you might have to be a little bit like, you might have to sort of, I wouldn't say be creative, but think, well, in reality, can this person really do these? Can this person really achieve all those outcomes we were talking about, A to G, on their own without any help? You know, maybe they need some prompting. Maybe they need somebody checking on them. Maybe they need some help for part of the process. So don't think just somebody, if somebody can do it at all or to some extent, that means they don't need help with that particular task. And then also the person may have fluctuating needs. So for some periods of the year or some periods of the day, or sometimes on a good day or a good week, they may be able to do them, but other times they may not be able to do them. So if that's the case, then a longer period of time needs to be taken into account. Because in reality, if they're going to have periods where they can't do these things, where they can't achieve things without help, they're going to get into huge difficulty at some point. You know, maybe not today, but maybe next week. Difficulties will arise if they don't have the help they need. Just in practical terms, does the Care Act say anything about how quickly a Care Act assessment needs to be done? Well, the answer is no. But as I've said, there shouldn't be a waiting list to even start the Care Act assessment. It must be carried out over an appropriate and reasonable timescale, taking into account the urgency of needs. So if the needs are very urgent, either the assessment needs to happen very urgently, or social services must put in something in place very urgently pending the assessment while they carry out a more in-depth assessment. They may need to just urgently meet the needs before they've completed the assessment. And that's under section 19(3). And of course, we want assessments done quickly, but we also want assessments done thoroughly. So that's a bit of a tension there, because you may be saying to social services, look, I really need this done very quickly. This is very urgent, but at the same time, I want it done very expertly. So if you're in that sort of situation, you may want to say, well, actually, put in place something now while you do a more thorough assessment. How are we doing for time? Let's see what we've got to get through. So after the assessment's been completed, after the Care Act assessment's been completed, there needs to be an eligibility decision, i.e. does this person qualify under the Care Act for services? And that's what we call a public law decision. So it should be written down somewhere, and different councils have got different ways of doing it. It's usually at the end of the assessment, but some councils do it on a separate document, the eligibility decision. And because it's a public law decision, it has to be made rationally and according to public law principles. So it has to be done according to the Care Act, so all of the things that we've been talking about, also the Human Rights Act, the Equality Act, and case law. And if you're kind of in doubt about whether, if you don't agree with the Care Act assessment and you're in doubt, I can make some suggestions. I'll make some suggestions at the end. But moving on, so we've had the Care Act assessment now. Assuming the person is eligible for services under the Care Act, what are the next steps? So the next step is going to be care planning, so that the needs that have been identified through the assessment can then be met. I'm just going to mention Section 18 of the Care Act here. Yep. Thank you, keeping up. So if somebody is eligible, that gives the person a legal right to actually have services. If somebody's eligible, something must be done to meet that person's needs. That's kind of non-negotiable. What will be negotiable is what actually needs to be done to meet their needs, but those needs must be met. There are some sort of caveats to that. So the council may say, well, the person's not ordinarily resident in the area, and the other thing is the means test. But if it's a young person who's never worked and doesn't come from a wealthy family, they will qualify under the Care Act means test. Well, there's two different types of means test. So there's a means test which is around a person's savings, their capital, which you probably heard about in relation to older people, which I don't think is really the focus of this room. So there's that means test, which is the upper capital limit is £23,250. So obviously if somebody owns a property themselves, they won't qualify under the Care Act. But I don't think that's a concern of people here, because that wouldn't really be relevant to young people. But there's also another means test which is around which is around charging for care. And that's something that's a very live issue and does affect even young people, and gives a local authority even a right to take money from people's benefits. And I mean, I haven't got a separate slide on that, but that is something that people should really try. If they're being charged too much, they should really try and get some advice. Some of the local disability organisations are very good at giving advice about how to challenge care charges, because they shouldn't be so high that somebody doesn't have any money left to actually do anything with their life. So I'm seeing a lot of nods in the audience here, so I'm assuming that this is more of a live issue than the actual capital means test, is the sort of assessing somebody's ability to pay for their services. Yeah. So, somebody at the back wanted to ask a question. Yeah.
It's more or less agreeing. My daughter is 45 and lives with us.
Right.
But she's got a clear package.
Mm-hmm.
But we are means tested as a parent. They means tested us. And what she gets her benefits. But they means test us because we both work. You know.
Towards her care services. That sounds really, I mean, obviously, like I said, This is general. I can't give specific advice because I don't know the circumstances. I've literally never heard of that before, and it sounds very, very wrong to me. So, yeah, if you want to get in touch, please do. But it sounds really, really wrong. I don't know how that could have come about. There may be more to it than I know, but that sounds very strange to me. Right, so we're moving on to care planning under the Care Act, and that's really at sections 18 and 25, and I think 26. Generally speaking, actually, a good tip about the Care Act is as you go through the numbers of the Care Act, I've talked about section numbers, as you go higher up the Care Act, you're kind of going through the Care Act assessment and planning process. There's a sort of logic there. So you're progressing from section 9, which is the assessment, through to the eligibility decision section. There's a kind, do you see what I mean? There's like a logical progression through the Care Act if you're trying to find your way through the Care Act section numbers. So a care and support plan must set out the needs that the local authority is going to meet and how it is going to meet them. So you get your Care Act assessment and you can see that it says, oh, they've got all these eligible needs, there's all these things that they need. So it's going to be hopeless if you see a care plan that doesn't actually set out how those needs are going to be met. So that's a really important thing to look for. And we know that the key issue, and I could see it from, I just sat in on the last 5 minutes of the last talk. Money comes into everything. The availability of resources, of social services pervades everything. And in law, it has been challenged in law, how much a council can take into account its own finances, its own funds, when deciding on a care package. Are they allowed just to say, oh, we'd like to give you this, and we think he needs this, but it's too expensive? And that's not a very easy question to answer in a single sentence. But the law generally says that the local authority is allowed to take into reasonable consideration its own finances and budgetary position, but it doesn't mean choosing the cheapest option. They can't just say, we're going to choose the cheapest option for this person. They must also think about the person's actual needs and whether this option will meet the person's needs. And it should, they're entitled to deliver the outcome desired for the best value. But that can't mean, so I suppose what I'm saying is that there's a balance to be struck. And you'll be saying, well, if you offer the care package in this way, it's not actually going to meet that person's needs. Whereas they'll be saying, well, it does, it's just a cheaper way of doing it. So there's obviously going to be, and then you have to think, yes, but have they thought about their well-being? You'll need to be thinking about how you reply to that and saying, actually, it doesn't really meet that person's needs because you haven't thought about X, Y, and Z. Does that make sense? It's kind of, there's obviously going to be a balance to be struck, and there's going to be arguments to be made about whether what they're offering, which probably will be, they probably will be trying to find a fairly cheap care package, and you'll be trying to say, well, actually, no, because of this person's particular circumstances, and because of their well-being, and because of their particular issues, and because of their positive behaviour support plan, and because of this medical evidence, and because of this and because of that, they actually need something better. And a care plan must also include a personal budget which sets out how much the local authority will spend on the care package. So what kinds of services can you get under the Care Act? A care package, obviously, through direct payment or agency workers. Support with activities, training, or help with work experience. Support outside the home. Transport, but not transport to medical appointments, because that should be provided by the NHS. Specialist accommodation, but not accommodation that can be provided under the Housing Act. So you can't use the Care Act as a way to sort of short-circuit the waiting list, or the bidding for a property. You can't, if you're just trying to get ordinary accommodation under the Housing Act, the Care Act won't really help you. And you can get respite. So these are just examples. In theory, you should be able to get anything that will meet the person's needs. At the care planning stage, a council can take into account the role of an unpaid carer, and a council can say, well, we can see this person has got these needs, but we're not going to provide for these needs because the person's got this unpaid carer, their family member, to provide this service to them. But an unpaid carer has to be willing and able to carry on providing unpaid care. If the carer is not willing and able to do it, then you can tell the council that. You don't have to give excuses. You can just say, I'm not prepared to do it anymore. I can't do it anymore. I don't want to do it anymore. I want to go back to work. I need to focus on myself. I'm not well. And also, related to unpaid carers, unpaid carers are entitled to carers assessments. You may have had them as a carer of a child, but you're also entitled to them as a carer of an adult, a carer's assessment. And the assessment process is really similar to the Section 9 Care Act assessment of the disabled person themselves. But it's got slightly different criteria. It's got slightly different eligibility criteria. And the sorts of things that the social worker will be looking for is whether the carer is able and is likely to continue to be able to provide care for the adult needing care, whether the carer is willing and is likely to continue to be willing to do so, to provide the care, the impact of the carer's needs for support on their own well-being, so we're back to those well-being criteria again, and the outcomes that the carer wishes to achieve in day-to-day life. So, could be about things like working or looking after other family members or leisure or health or anything. In scrutinising, when you see an assessment or a care plan and you are concerned, there's a number of things to sort of take into account. So the first thing is that if a local authority says to you, well, I'm not doing the assessment because the person refused to have an assessment, they need to think whether that person actually has mental capacity to agree to an assessment or to refuse an assessment. And the other thing is advocacy. So it may be that you think, well, it would be good if the disabled person has an independent advocate. You may have advocated for this person for years, but you may want them to have an independent advocate now because you feel that you don't want to do that role anymore, or because there's a conflict of interests, or because you think that that person wants to say something basically different from what you may want to say. If that's the case, or if the person hasn't got a family member to advocate for them, they're entitled to an independent advocate. These are a few extra useful things to know about in an assessment. That the person doing the assessment, so this is Section 5 of the Care and Support Assessment Regulations, which says some useful things about how an assessment should be carried out. And the person doing the assessment should have the skills, knowledge, and competence to carry out the assessment and should be appropriately trained. And the next slide is really saying that they need to be bringing together information from different sources. They need to be taking on board any the views of somebody who's got expertise, say a particular medical professional, or maybe an educational, a teacher or something like that who has specialist knowledge, or an OT about this person. And they need to take that on board as part of the assessment. And another important thing is for people with autism, there's another act called the Autism Act, which people lobbied long and hard for, but actually doesn't make a huge amount of difference. But there is some useful guidance published under the Autism Act, which I've provided a link for if you want to look at it. And it says that people with autism, they're entitled, when they have an assessment, they're entitled to have an assessor who has specific expertise on autism. So that's another important thing to check.
Does that apply when they have learning disabilities and medical requirements as well?
What, the expertise?
In autism, so I would request that alongside, you know, because if I'm having an assessment, or he's having an assessment from somebody from CLBT, they might only be versed or experienced in learning disabilities and not autism in its entirety.
Yeah. So if there's somebody who's worked with that person who's got expertise in autism, or if there's somebody that they've been referred to before who's done an autism report about them, or if there's some service that they go to that's very specific to their autism, or if they've got a positive behaviour support plan that relates to their autism, all of those would be useful bits of information to add in. So there's kind of two. It applies under the Care Act and also under the Autism Act, that any expertise or any expert reports should be brought together under the Care Act assessment. But for somebody with autism, then they've got an extra entitlement to have somebody who's got specialist knowledge of autism involved in their Care Act assessment or doing their Care Act assessment. I mean, it's quite hard to know sometimes because you don't know the qualifications really or the training of the person who's doing it. But sometimes you think, this person hasn't really understood, or it may be that the person, I don't know if there's anybody from RGB here, but I'm noticing more and more that, you know, that sometimes it's not even, I'm not even talking about experienced social workers. Sometimes it's not even a social worker doing it. It's like a social care. There's a new grade that's below a social worker doing it. And I think it's also always worth asking the question, how much experience has this person got of autism? I think it's really, really important to ask that question. And you're entitled to ask. You know, you are entitled to ask. It may sound a little bit offensive because it may sound a little bit... I'm sure you can find a nice way of asking. So... yeah. Oh, sorry. Sorry, RBG, Royal Borough of Greenwich. I probably said it the wrong way. Royal Borough of Greenwich. Sorry. I'm trying to be jargon-free, but I think I didn't even say it right, did I? Royal Borough of Greenwich. I don't know if the Royal Borough of Greenwich people, and I don't want to malign Royal Borough of Greenwich. Yeah, because I don't think they're the worst borough, actually. Anyway, you may have a different view, but I don't think, from my experience, they're not the worst. Anyway. The Care Act and immigration issue. So there are some. It's sometimes an excuse, and it's sometimes there's sometimes different legislation applies. So people who don't have people who are in the UK outside of the immigration rules are sometimes excluded from getting services under the Care Act, but if it would impact on their human rights not to get services under the Care Act, they still should get services under the Care Act. And asylum seekers should get services under the Care Act. Obviously, if they're a disabled person, they need services under the Care Act. That's what I'm talking about. And I just wanted to point out that it's different from the no recourse to public funds condition, which people will have heard about. So we're not the Care Act services are not a public fund. They're not a benefit. People shouldn't be excluded from having services under the Care Act because they're also excluded from benefits. The two things are separate. And like I said, if it would be a breach of their human rights not to get Care Act services, then somebody even who is here in the UK not under the immigration rules would still be entitled to services under the Care Act if they need them to avoid a breach of their human rights. And it's a very complicated area of law. There's a lot of litigation around it. There's been a lot of legal cases around it. It's a complicated area of law, so if you or somebody you know is in that situation, I do recommend getting legal advice around that. So I'm going to move on. So we started at 2:10, didn't we? So have I got till, sorry, 1:10. So have I got till 2:10? Is that okay with everybody? Yeah? Okay. Oh, okay. I said a few words before about Care Act and housing is such a huge issue for people that they often think, well, look, I'm living in this really, really unsuitable accommodation with my disabled child or family member, and I've been on the waiting list, I've been bidding for years trying to get better accommodation, or I'm in temporary accommodation, and they often think, well, can I get housing instead under the Care Act because my child or my family member's got all these disability-related needs? And the answer is, generally speaking, no. You can't, if you're entitled, if the person's entitled to housing under the Housing Act, and what you're just looking for is a move, rather than any specific specialist type of accommodation, such as supported accommodation or a care home or something like that, then the answer is generally no. You can't use the Housing Act you can't use the Care Act to bypass the Housing Act. I just wanted to mention a little bit more. I mentioned that Care Act decisions are public law decisions. So what I mean by that is you need to sort of think about what is the decision you want to challenge. Do you want to challenge the fact that the council's refusing to assess? Or do you want to challenge the Care Act assessment itself? Or do you want to challenge the care plan? So each of these stages in the Care Act are things that you may think you disagree with. You may disagree with the council's conclusion, and you may want to think, how can I challenge that particular decision? And it is really important, just going on to the next slide, it is really important not to wait too long, because in public law, in judicial review, you've only got 3 months from the date of the decision to challenge it. You know, if you think an assessment is completely wrong, they've said that your child isn't entitled to any services and you want to dispute that, you've literally got 3 months to challenge it in law. There are other ways to challenge things, which I'll talk about in a second, but you've only got 3 months, which is very, very little time to challenge it. So if you're in doubt, try and get legal advice as soon as possible. So what would an unlawful decision look like? So an unlawful decision isn't necessarily just a decision that you disagree with. So quite often something like the council saying that somebody only needs 25 hours of care a week when you think that they need 35 hours of care a week, that might be quite a hard thing to challenge, because that's going to be the social worker's view of things. You'd need to have very strong evidence for that. So it's quite often not something, an unlawful decision is quite often not a decision that, we're not talking about a decision that you simply disagree with. It would need to be a decision that you could show is in breach of the statutory guidance or the Care Act legislation, that something was done very wrong with the assessment. For example, there wasn't the specialist autism involvement in the assessment, that the person didn't have advocacy when they were entitled to the advocacy, that the assessment or care planning, that it didn't take into account very relevant things like very relevant medical reports or other reports that you may have, OT reports. It may be that you think that it's discriminatory or it's in breach of the Human Rights Act because it's actually leaving the person in such, difficult, squalid conditions without the care that they need, that it's inhumane, which would potentially be a breach of their human rights. And another thing to look out for with a care plan is if the care plan doesn't actually meet the needs that have been identified in the needs assessment, then that would potentially be unlawful as well. And how do you remedy the situation if you've got an assessment or a care plan or a decision that you think is unlawful? Well, one remedy would be through a judicial review, and that would obviously involve finding a solicitor to do that and getting legal aid. Another way would be to make a complaint. And another way, and I think a lot of people actually do this, is that they think, well, I'll get better evidence, and then I'll go back and ask for another round of review or reassessment, because reviews are meant to happen yearly, or initially 6 weeks after a care plan's put into place, but thereafter they're meant to happen yearly. So you can kind of build up to the next review or the next reassessment, or you can say, well, look, the person's circumstances have changed, things have got worse for the person, I've got this new evidence, so I want to have another go at doing this reassessment or a review, a care plan review, or a review of the assessment. So in a way, it's kind of just going background for another bite of the cherry, and you can do that. You're entitled to do that if you've got a good reason for asking for another assessment. I just want to, I know we haven't got very long left, but I just wanted to talk about the Mental Capacity Act, because that's really, really important, and I'm not sure how many people have kind of come across this in their daily lives as a carer. But it is a really important legal framework for people, and it's the framework that kicks in when a person lacks mental capacity to make decisions about what care to receive or where to live or other key decisions in their life. It might be actually things about sex and relationships or social media or finances or other things as well. And this other legal framework is the Mental Capacity Act 2005. Like I said, it's a kind of another framework of law, and so it's not a question of the Care Act or the Mental Capacity Act. Both bits of legislation could apply to the person. There's some principles under Section 1 of the Mental Capacity Act, which is that a person must be assumed to have capacity unless it's established that they don't. You need to help the person to take practical steps to help the person to make that decision. So, for example, just a really obvious example, if the person was deaf, you wouldn't assume that they didn't have capacity just because they didn't understand you speaking. You'd have to use, sign language interpreter or lip speaker or whatever. So you'd need to take those practical steps or use easy read materials or whatever to help them to understand the decision. A person is not to be treated as unable to make a decision merely because he makes an unwise decision. So these are the principles that are set out at Section 1. And anything you do for a person who lacks mental capacity must be done in their best interests. So what does it mean to lack capacity? And this is summarised at Section 2 of the Mental Capacity Act, that a person lacks capacity in relation to a specific issue if at the time he or she is unable to make a decision for himself or herself in relation to the matter because of an impairment or disturbance in the functioning of the brain or mind. So just to put this into everyday language, it's applying to people who have some form of mental disability, whether that's to do with a mental health issue or a learning disability or autism or dementia or something like that, and it's that they lack capacity to make a very specific decision. So somebody doesn't have capacity or lack capacity generally, it's in relation to a very specific thing. So what are we talking about? Maybe it's a decision about where to live or what care they should receive. So it will be specific to a type of decision. It's not all or nothing. You might have capacity to make decisions about one thing, but not about something else. And if a person lacks capacity to make a particular decision... Oh, okay. We've run out with the slides. I wonder... Oh, okay. Maybe the link's gone down, do you think? Has the link gone down because of the end of the... because it's gone 2 o'clock? You've got it. I'm not sure. You've got it, but I'm not sure if there's people on. Are there people online, or is this just being recorded? I'm not sure. You've got a copy. I'll just wait to see whether they want me to carry on or not, because I don't want to do the wrong thing. Should I just carry on? Yeah. Okay. I'll just carry on because we're nearly there, and I just want to do a really quick case study at the end to think about. You've got it in front. Okay. Lovely. Okay. So. We were just talking about, so if somebody does lack capacity to make a particular decision, decisions must be made in their best interest. So what do we mean by that? That those decisions must take into account that person's wishes and feelings. So just because somebody lacks capacity, it doesn't mean they're out of the picture in terms of the decision making. You know, their wishes and feelings are incredibly important. You must also take into account their beliefs and values. So that might be, you know, beliefs is quite broad. It's like how they like to live their life, or it might be about their religion, or it might be just their personality, something like that. Family members and the person themselves should always be asked what they think is in that person's best interest, what they want. And if it's a decision, if it's a really fundamental decision about where to live, the person themselves should have an independent mental capacity advocate if there's no suitable family advocate. So I'm saying this because it's really, really important that if you've got a child, an adult child, or you know, another family member or somebody else that you care for who doesn't have capacity, it's not either for you yourself or for social services to make a decision about where that person should live. It must be done under the Mental Capacity Act. The person must have if you disagree with the person themselves, or if that person doesn't have a family advocate, they should have an independent mental capacity advocate. Yeah. Sorry, I'm going to say it again. It is really important. So, if there's a disabled adult who lacks capacity to make a decision about where they want to live or where they should live, and you might have a different view of things from that person, and social services might have a different view of things from that person. It's really important that that person's views are taken into account, and it's important that that person has an independent mental capacity advocate, and it's important that decisions are made in their best interests, but they shouldn't be cut out of the process completely. Their wishes and feelings need to be taken into account.
So sorry, you as a carer.
Yeah.
What say? I mean, you've just said that we don't have a say.
No, I'm not saying you don't have a say. You do have a say. You do have a say, but what I'm saying is that your say is not the only say. But also social services, importantly, social services view of it's not the only, that's not the last say either. If you have deputyship, that's a really, really good question, because sometimes yes, but sometimes no. Yeah. So I'm just going to get into this a little bit more. And the thing is, I was asked to talk about the Care Act in this presentation, but I thought, well, actually, issues under the Mental Capacity Act are going to be really relevant to you as well. So that's why I'm talking about this. But maybe I should have started with this, because I can see that everybody's very, very interested now. But we're down to the last 5 minutes. So if there's a dispute under the Mental Capacity Act, what kind of disputes arise? So it could be a dispute between you as the parent carer and social services about where the person should live. It could be a dispute between you and the disabled person about where they should live. It could be a dispute between social services and the disabled person about where they should live, or it could be a dispute between different family members, between maybe, you know, the father and the mother, if they're, you know, particularly if they're separated, and you have this a lot with, you know, old people, you know, children and people with dementia. We know that, but I don't think that's the audience here today. So those are the types of dispute that arise. Resolving, we hope that that disputes can be resolved under the Mental Capacity Act through dialogue, but quite often it is important to take these cases to the Court of Protection, particularly if the disabled person themselves doesn't agree with what everybody's deciding for them. I know that's quite difficult, and it's something that people don't want to hear, but I'm doing this from I come from a disability rights background, and I'm thinking, well, there are circumstances where we need to think about the disabled person at the centre of this. Adults, parents who've been looking after a disabled child may be very, very in the habit of making decisions about or for a disabled child. But it gets to a point in that person's life where their views are taken more and more seriously by the courts. And the Mental Capacity Act kicks in aged 16. And they need to be, their view needs to be heard. So the Court of Protection is set up really to make decisions for the person, the disabled person known as P, in the Court of Protection, who's at the centre, who's at the heart of all this decision making, because otherwise you could have a situation where this person is moved somewhere for everybody's convenience because the carers are really, really exhausted, or maybe the carers think it would be good for them and social services think it might be good for them, but we mustn't forget the person at the centre of this all. So just the last point, the last bullet point is also incredibly important on this page. We're still on this page. If a person's freedom is restricted, so if they're moved to, for example, a care home, even if it's a small friendly group sort of home, or if they're moved to supported accommodation, and their freedom is restricted because they can't necessarily go out exactly when they want to go out, because if they try to open the front door, they'd be brought back, or because they don't have the keypad number so they can't get out themselves. And it may be for good reasons, for their own safety, so they don't run into the road. But if their freedom is restricted, in law, that's seen as a deprivation of liberty. And going back to your question, no, a deputy cannot authorise a deprivation of liberty. Only if it's supported accommodation, only the Court of Protection can authorise that. You're quite shocked, but that's what the law is. And you do find that even social services sometimes are not aware of the law. So very, very important principles here. That's me done. We're kind of I've just about finished on time, but I have got a short case study if you want to do this, if you want to stay behind to do the case study. And if you want to ask questions, I'm happy to answer questions. Does anybody want to, if you haven't got questions, would you like to look at the case study for 5 minutes, maybe? So the case study is... yeah, so I've got a case study. The next... It's case study? Is it? Oh, well, right, okay. Last page. I've got a case study here. You might want to sort of look at it and talk to somebody next to you. And then I can go through it in 5 minutes. But it will just help to kind of maybe consolidate what we've been talking about and apply it. And hopefully this has got some relevance to you, this type of case study. Have I read your mind? It's your life. Okay. I probably know a lot of women like you, just from, yeah. Have you got the... Okay. Yeah, sure.
Once they become an adult,
Mm-hmm.
once they're children,
Yeah.
the majority of carers are responsible carers.
Yeah.
Once they become 18
Mm-hmm.
and they're adults in their own right, I think sometimes it's a bit of an insult when you have professionals coming in and saying, you need to do this or you haven't got a right to do this, when you've been doing it for the past 18 years.
Mm-hmm.
I think it's an insult because you must have been doing something right for the past 18 years. So why is it after 18 years they start questioning you?
Are you talking about this from a kind of mental capacity? Are you talking about it from a sort of mental capacity perspective? That they're sort of saying, yeah, yeah.
Travels in, one weaves into another. Before 18, that's fine. You're a responsible adult. Yes, you're doing a good job. Suddenly, they start, I would say, questioning you. Why are you doing this? Do you think this? My son's capacity is still, although he's an adult, he's still like a child in some respects. Now, although I treat him, try to treat him as an adult, a lot of it goes over his head. You know, he doesn't understand. You have to break it down. So I don't understand why, and it's not just me. I hear other carers saying, up till the 18 I was fine. Suddenly I'm being questioned and sometimes interrogated by a professional. Why are you doing it this way? He's an adult now. He should be making his own decisions. Well, my son can't make decisions himself because he'll be walking around naked with a thing in place. Well, that's if I'm lucky. You know, it's an insult.
I mean, it may be that it may be a different culture between. I can't say precisely a different culture between children's services and adult services. So children's services may have one attitude, and adult services may have a different type of training and different attitude. So that might be one explanation for it. Another explanation for it may be, I mean, I can't say because I don't know what's happened and I don't know what in general. It may be that actually children's services, in a way, have not given. I mean, nobody should be coming in to, no social services should be coming in to a family home and criticising. They should be trying to support you to do the caring role that you're doing. Yeah, they should be, yeah.
They are criticising.
Yeah,
They're very good
okay.
at what they say. They've got a way of saying things and they think that you're that stupid, you're not going to realise what they're doing. Well,
Well, I mean, yeah, I mean, I'm not here to defend social workers, you know, I don't know how they've behaved with you, but what I am aware of is the law, and that's what I'm trying to sort of explain today. But although a child becomes an adult aged 18, and although the Mental Capacity Act kicks in age 16, and although the Care Act applies age 18, and you've got these very rigid ages when things kick in terms of law, actually what the law says is that even from the age of around 12 or 13, a child's views should be taken into account more and more, depending on that child. So as a child kind of approaches adulthood, their views should be taken into account more and more, and they should be seen more and more as a kind of an autonomous person. But I mean, obviously nobody should be, that doesn't give anybody justification for coming in and criticizing you. You should be provided with the support you need to help the person, to care for the person. You should be receiving what you're entitled to as a carer, and your child or adult child should be receiving the support that they need as a child or as an adult. But there are circumstances where differences of view arise. And I'm just trying to reflect that in this case study and in the information I've been giving you about the Mental Capacity Act. Should we just talk briefly about the case study if you want to? Yeah? Okay. But happy to talk afterwards if you want. Yeah. If you've got to rush off. Okay. If you've got to rush off, yeah. Right. So just looking at the case study, I mean, I'll talk through it unless you want to volunteer information. I'm happy to talk through it. So your daughter's 17-year-old with learning disabilities and autism. Family carers are exhausted and worried about the next stages in her life. You want a bigger care package. How do you get a bigger care package? Ask for an assessment. Ask for an assessment. Make sure that the assessment is done by somebody who's got the right qualifications, the right expertise. Think about who needs to be involved in the assessment. Does it need to be is there educational information from their education that can be brought into it? Do they have a positive behaviour support plan that needs to also be, that's also sets out certain things that this person needs? Is there specific medical information that you can get from the GP or from a specialist? So think about all of those things that you can bring in to the assessment and say to the person doing the assessment, look at this document, look at this, talk to this person, talk to that person. So that's the, yeah.
In fact, that is so important because as these kind of assessments, it would never occur to me that I have the right to direct it in any way. We just think that someone will come do an assessment, it's this mysterious process. We don't get to steer it or to advise on who should be involved. And that's quite a big takeaway from today.
Good.
I have always been here in the meeting. For me, I take it as witness.
Mm-hmm.
Because whatever I tell the social worker, the next day will say, no, you didn't say that, I didn't say that.
Yeah,
So
yeah.
the more people that are just as witness,
Yeah.
make sure things get done.
Yeah,
Whether
yeah.
it's behavior specialist or
Yeah.
the care coordinator from all streams.
Okay,
So it helps
okay.
when we bring more people who are specialists
Yeah.
and to push, to add weight to your
Yeah.
community.
And they may not necessarily, so this information coming in from different sources, it may not be all as part of the assessment meeting. It could be a document that comes in, or it may be the conversation that they have, that you say, talk to this person. Or, so it doesn't always have to be as a kind of a big meeting, everybody doing the assessment together. But they need to somehow gather all this information in. And if you've got information, if you've got reports from other specialists, etc., you can feed that information through to the specialist.
Because most of the people get discharged after 5 or 6 sessions, and then you fall off the system. So it's hard to keep to have someone for the care assessment, because for a new referral to get someone professional to be involved, it takes longer than anything.
Yeah. I suppose you could always say, well, actually, the assessment, this comes back to that issue about having a thorough assessment. You could say, well, actually, I don't think this assessment is completed until this extra bit of it happens. until you've also talked to this professional or until this referral to this professional's happened. But in the meantime, I'm desperate for some services, so put in some services in the meantime while we get a really thorough assessment. That might be one approach you could use. Yeah. So you want a bigger care package. I've said, you know, could try for an assessment to get a bigger care package. If you're exhausted, you could also ask for a carer's assessment to see what services you might need as a carer, or see. Right. 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 Okay. So if it's 16 plus, so that they, I don't know what bit of the government website you're talking about. They may be talking about transition planning, but even if the person's a child, then you're still you can still be entitled to a carer's assessment because you're caring for the child. So either way, you should be entitled to a carer's assessment. Yeah. So you could get a care package for yourself, or you could get a bigger care package for the person you're caring for to help you. So either way, yeah. Okay, I'll have a look at that on their website. So the next bit was the sort of the more contentious bit that we were talking about before, that social services says she should move into supported accommodation age 18 if she needs a bigger care package. And your daughter doesn't like change, and you don't think she'll want to leave home too soon before she's ready. So I just wondered what you thought about that, because that's quite a common scenario. You know, you're saying, well, she wants to stay at home. I'm really happy for her to stay at home, but I can't carry on like this. I've been caring for her for 18 years. I can't carry on like this. And the point is that if social services, if your daughter, age 18, doesn't have mental capacity to make that decision themselves, she cannot be moved out of the house into supported accommodation. It's simply not lawful for that to happen. Social services can't bully you into that, because you've got a right to put your view to the Court of Protection. And really, really fundamentally, your daughter has got rights on her own to put her view, and she'll be assisted in the Court of Protection process. She will be appointed a litigation friend to represent just her view, her interests, because if it's in her best interest to stay at home, I mean, if the barrier to her staying at home is that the support package isn't big enough, you know, she can't just be moved into supported accommodation for the convenience of social services. And that's a really, really fundamental point. So if you take away one thing from today, I hope it's that. Yeah. So, but that, it kind of affords extra protection to people who lacks capacity. And this is the thing, there's a slightly two-tier system between people who lack capacity and people who've got capacity. And in a way, you've got this extra framework of rights under the Mental Capacity Act for people who lack capacity.